Hello, everyone. It's Antoinette Jefferson. This is Antoinette's podcast, and I am bringing you another episode regarding law, race, and the Constitution in the Obama context. And for the last several weeks, the last 5 weeks or so, I have been discussing the Houstonian approach to law. So I just wanted to give a brief update by way of what I have been discussing. But first, I wanted to start by saying I am the author of 10 books, and I possess 6 degrees from 6 different universities, and 3 of them are law degrees, a Juris Doctor degree from the George Washington University Law School, and 2 LLMs, a Master of Laws from American University and a Master of Laws from Cooley Law. And I also possess 3 additional degrees, a Master of Social Work from Howard University, a Master's in Communication from Trinity, and a Bachelor's of English Arts from Hampton University, where I graduated magna cum laude. Now, what I have been discussing is I've also worked for several firms in corporate America, so to speak, with these firms, and had several other positions throughout the way, really paying my dues and earning my keep along the way. Now, what I've been discussing recently is African American attorneys, the business of law or the business of change. And the subtitle for my book, Law, Race, and the Constitution in the Obama Context, the subtitle of this particular essay is Charles Hamilton Houston's Contributions to the American Legal Context and the Reinvention of the Social Engineer in the 21st Century. So I talked about Frantz Fanon and set up the theoretical framework in terms of the context being one in which American blacks or black Americans in the United States have a similar experience in certain ways to the colonial context that occurred across the globe in terms of some people may call it second-class citizenship, but not everyone believes that African Americans have had a second-class citizenship. Even though African Americans did, or Black Americans did undergo or experience enslavement. But since that time, there have been several changes and iterations in Black life, including the Civil Rights Movement, the Black Power Movement, and certain other iterations, including with the first Black presidency under Barack Obama, and certain other seminal time periods in Black life, including court cases and certain other, and even most currently or most recently, the Black Lives Matters movement, or Black Lives Matter movement. So now I'm looking at Charles Hamilton Houston, and what I looked at in the past several weeks was again, the Frantz Fanon context, which was the Wretched of the Earth, and from his book, The Wretched of the Earth, and his theoretical paradigm of the colonialism, where it is difficult to compromise the privilege with which one has been imbued, whether a majority race or minority races. If you benefit from a particular context, it's difficult to compromise that benefit, especially if you worked for it or earned it. I also began to discuss the Black lawyer or the Black professional as a mediator, and a mediator in the context of the larger society and political institutions, cultural institutions, social institutions, educational institutions, and in the micro context or micro meso context in terms of the family units, and then in the individual context in terms of an African American professional or an attorney earning one's livelihood, one's ability to make a living, and the role of the African American professional attorney in being a mediator, being a negotiator, being that vanguard as an attorney that works to promote the interest as an advocate of Black Americans, and also works to promote the interest of the society at large, being an attorney, being a professional. So you have to navigate several systems, and then also what it means in the individual context and in the family context. I looked at several different movements, the civil rights movement and certain other um, uh, uh, time periods in terms of the Houstonian time period that dovetailed or that occurred simultaneously with or prior to simultaneously with and thereafter the civil rights after the civil rights movement. His legacy did live through those time periods as an attorney who had impact on peremptory challenges and who had an impact on criminal procedure and criminal law. The idea of criminal or criminal lunacy or insanity or black inferiority, what was perceived to be as black inferiority, and how that played a role in the criminal context in terms of defenses and complicating that idea of a criminal mind or an inferiority complex among African Americans who face the criminal justice system. So now I'm going to look at a few of the cases that were impacted by Charles Hamilton Houston's advocacy. And I ended again with his impact in terms of criminal law and the peremptory challenges and also sociological jurisprudence. Now I'm picking up here. And still in Tunstall, labor law became, this is a case in the Tunstall case, labor law became an issue where blacks were excluded from the labor union and deprived of seniority rights respectively. Such egregious discrimination could not go unaddressed. Houston effectively litigated the case, and it was held that the Railway Labor Act imposed a duty to engage in fair representation. Houston and the Hollywood 10, which was a very famous case, and the Scottsboro Boys cases, which was also very famous, argued for First Amendment, Fifth Amendment protections, and the fundamental right to political affiliation. His social engineering approach was to defend the Hollywood 10 from persecution during a time when the United States was hostile to communists and those who sympathized with communism. His unbridled concern for justice outweighed any adverse risks of affiliations with a radical party. In fact, he was dedicated to democracy as evidenced by his service in the United States military and his following of constitutional principles during the course of his life. Again, this points to the idea that social engineering operates within the confines of the quote-unquote colonized society, where social engineers ascertain their legitimacy through the observance of societal practices. Environmental law is another core facet upon which Houstonian social engineering had and continues to have an impact. Housing, school, and employment environments not conducive to equality and fairness have been attacked through the Houstonian approach. The idea that the environments where persons live, work, learn, and have their leisure be free from oppression and injustice has become normalized in the American context. Although the practice is sometimes very different, it is at least in theory that society purports to enact environmental justice. The move from theory to practice is still in process, but the process is indebted to Houston for his tireless efforts in creating opportunities for African Americans. The impact of lawyers today are demonstrated in courtrooms and firms, public interest nonprofits, and government, but there's been little in the news regarding African American attorneys playing the role of advocate for justice. Rather, today's attorneys work through less radical means to quietly enhance the relative wealth and health of what Du Bois termed the talented 10th. Because there is no imminent threat to the lives of African Americans, the role of black professionals and strategies for change have adapted to the context in which we live. The point of becoming an African American professional is to create a better life for oneself rather than to sacrifice for the race. Seminal cases in the mainstream media as of the last 25 to 50 years have been the O.J. Simpson trial, the Rodney King proceedings, the controversy concerning Michael Jackson, the Jena 6 case, and the election of Barack Obama. However, These cases seem to be distinctly different than the earlier constitutional cases argued by Houston, although there have been cases such as Shaw v. Reno, which dealt with racial gerrymandering, and Batson versus Kentucky, which dealt with race-based peremptory challenges, U.S. versus Armstrong, which dealt with disparity in crack and cocaine sentencing, Richmond versus Croson, which dealt with affirmative action in municipal contracts, Adirond, which dealt with affirmative action and contracting, Grutter v. Bollinger, which dealt with affirmative action in higher education, etc., etc. These cases have not garnered the media attention as other sensationalized cases involving race. The constitutional and state case of the past assumed the inferiority and criminality of African Americans and were couched in a system relatively uncharacterized by wealthy blacks or the massively sensationalized entertainment media of the 20th and 21st century. Today's struggle around wealth, fame, notoriety, public consciousness, and sensationalism of the law and media creates a complex web of dynamics in which social engineers or the legal system acting as social engineers operates. The O.J. Simpson trial essentially asked whether America was ready to acquit an African American male who had been accused of murdering a white woman. The fact that O.J. was a famous and wealthy African American man played into the analysis. The role of Johnny Cochran as his lawyer, a black attorney, seemed to create a particularly race-charged trial with black against white. Moreover, the American consciousness was at stake. Had America changed so much as to allow the legal process to acquit a man, or would race relations be a major mark against a black defendant? Surprisingly, although the not guilty verdict seemed a victory for the African American community, there were many African Americans who believed that O.J. was guilty and were therefore torn between racial solidarity and notions of justice along race-neutral lines. Johnny Cochran became the social engineer who used the law to mediate between the masses without regard to color and the elites, the sports and entertainment industry, as he created an opportunity for an elite black man, O.J. Simpson, to defeat the charges against him. Now, Michael Jackson's cases are also exemplary of the role of the legal system as social engineer. Here, while the attorney may or may not have been African American, the legal system played the role of social engineer such that Jackson's elite status would grant him special privileges. Michael Jackson had extensive involvement with the legal system concerning allegations of child molestation. However, there was a rift between those who thought him innocent and those who thought him guilty. However, this divide was not solely along color lines. The Jackson controversy defied traditional color lines, although it was not color neutral. Rather, race became a complicated factor in the midst of fame and wealth as prime determinants of guilt or innocence. Whether opportunistic families comprised of the majority or majority race members convinced of Michael Jackson's innocence, the color context would not be black or white. To indict Michael Jackson would be to indict America, as Michael Jackson was an American icon. The legal system thus social engineered change that erased color from the equation when weighing fame and wealth of a public image, child star, and American legend. Now, there are a few other cases that I want to address, and I'm going to address those cases in the next podcast. But we're going to look at the Rodney King case and the Jenna Six case. And last podcast, I believe I said I was bringing it to an end, and I am bringing it to an end, but it will be the next podcast where I'll bring a conclusion to this particular essay in the text, Law, Race, and the Constitution in the Obama Context. But here we've seen that there have been several cases that were affected by Houstonian logic, and not only Houstonian logic, but the social, political, and cultural context in which Black Americans and the greater society at large lived. Whether white, whether black, whether Asian, Latin, whatever, the native, whatever the race or nationality, we see that a lot of these cases crossed color lines. And even though color may have been a factor, though not race neutral, the complication of race in this context caused a new re-envisioned version of what race would look like in the 21st century. So this brings the podcast to a close for this week, and I'm looking forward to next week's podcast. So see you next time. Same bad channel, same bad time.